All right, thank you. Meeting will now come to order. Take roll. Commissioner Baker.
Here.
Commissioner Bluestone.
Here.
Commissioner Carruthers.
Here.
Commissioner Castillo.
Here.
Commissioner Solomon. And Commissioner Villanueva.
Here.
Thank you. And the chair is present.
Looks like we've got Commissioner Solomon joining us.
Okay, good.
He may or may not have video. It looks like he's joining on a phone. So
Okay. We can get him. Hey, Ron, are you there, Commissioner Solomon?
I'm here, Mr. Chairman.
All right, great. Thank you very much. All right. Approval of the agenda. Jeremy, before we head to that.
Thank you, Chair. Commissioners, we need to amend the agenda. This agenda was sent to you some time ago and was posted in accordance with the Open Meetings Act. Since then, there's been action on one of the administrative complaints on item 11. So in administrative complaint number 2021-17, the Deputy General Counsel concluded that that complaint is not supported by probable cause. Those findings were sent to the Administrative Hearings Office. The Administrative Hearings Office hearing officer has dismissed this matter. Based on the General Counsel's findings, the item 11A was on the agenda for a 90-day extension, but that's no longer needed because the Administrative Hearings Office hearing officer has dismissed the complaint. And so I would just seek a motion to amend the agenda to remove item 11A and 12A from the agenda.
So moved.
Second.
Thank you. Motion second. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
and Commissioner Villanueva.
Yes.
Thank you. Chair votes yes as well. The agenda has now been amended. And now is there a motion second to adopt said agenda?
So moved.
Second. Moved.
Thank you. Moved and seconded. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo, Carruthers, I'm
Yes.
sorry.
Yes.
Thank you both. Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. The agenda is approved. Now we move on to approval of the minutes of our last meeting, which was held June 10th. Is there a motion second?
So moved.
Move to approve.
Thank you. Moved and seconded. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva,
Yes.
and the chair votes yes. The minutes of the June 10th meeting are approved. And we'll now move into the substantive portion of today's program. Item number 4, advisory opinion 2022-07. Jeremy.
Thank you, Chair. Commissioners, we have 3 advisory opinions drafted for you today. I'll present the first 2 and Walker will present the third. So for draft advisory opinion 2022-07, on June the 3rd, the Commission received the following request. At the May 16th, 2022 Albuquerque City Council meeting, the Council passed floor amendment number 13 to the city's operating budget bill. According to an explanation contained in the amendment and to an official press release, the amendment added $250,000 for a council-directed sponsorship to Planned Parenthood of New Mexico. The operating budget bill was passed and then signed by Mayor Tim Keller. The questions presented to the Commission are: number 1, does the council directed sponsorship to Planned Parenthood of New Mexico, a private corporation, violate Article 9, Section 14 of the Constitution? And that, as you know, is the anti-donation clause. The second question is, does the council directed sponsorship to Planned Parenthood of New Mexico violate the procurement code? Those are the two questions presented. For the public that's following along, the draft advisory opinion is in the public materials at SEC 10 through SEC 16. And on page SE 16, the draft advisory opinion attaches the floor amendments with the explanation below. So in response to those two questions, the draft opinion concludes as follows. First, that the council directed sponsorship to Planned Parenthood of New Mexico under the facts presented and under this floor amendment that was attached to the request to the advisory opinion. Under those facts, there is no anti-donation clause violation for the following reasons. First, at the outset, it's unclear whether or not this explanation in the floor amendment is actually binding on Mayor Tim Keller's decisions with respect to the annual operating budget resolution. So the annual operating budget resolution, according to the Albuquerque ordinances and charter, is the resolution that constitutes the city's operating budget for the ensuing fiscal year. And this floor amendment language and the explanation in the floor amendment language was not in the Albuquerque's annual operating budget resolution. So it's not certain that the explanation accompanying the May 16th floor amendment constitutes an act by which the city of Albuquerque makes a donation to a private corporation. But even assuming arguendo that it is, that this floor amendment somehow binds the mayor in the expenditures of the city's budget, again, under the facts presented to the commission just with this floor amendment, there is no anti-donation clause violation because there are two exceptions to the anti-donation clause that might apply. The first is under subsection or section A of Article 9, Section 14. The anti-donation clause does not constrain the state or any municipality from making a provision for the care of sick or indigent persons. And there's been no facts presented as to whether or not this $250,000 that's directed from the city of Albuquerque to Planned Parenthood, whether it would be for the maintenance and care of sick or indigent persons or not. Second, the commission hasn't been presented with any of the grant language that would accompany this this appropriation. And whether or not the city of Albuquerque receives commitments in exchange for its provision of this $250,000 would go to the question of whether or not there's actual consideration. If there's consideration, then there's a contract. And again, under the anti-donation case law, that would operate as an exception to the anti-donation clause's prescription against making a donation or a gift to a private person. And so for all of those reasons, the commission hasn't been presented with any facts that would suggest an anti-donation clause violation. The procurement code question is easier to resolve. Under the procurement code, a municipality that's adopted a home rule charter, and if the home rule municipality has adopted its own procurement ordinances, under those two conditions, the procurement code does not apply. And so that's the case with the city of Albuquerque. The procurement code doesn't apply to city of Albuquerque procurement, and thus there couldn't be a violation of the procurement code based on this by the city of Albuquerque. And so with that, commissioners, I submit the draft advisory opinion to you for your consideration.
We'll entertain a motion in a second and then move on to discussion. Is there a motion in a second?
So moved.
Thank
So-
you. Moved and seconded. Any discussion, Commissioner Baker?
No questions. No comment.
Thank you, Commissioner Bluestone. Thank you, Commissioner Bluestone.
Thank you, Mr. Chairman. I simply want to say that I think that the analysis of the anti-donation clause is very well done and will prove very helpful in other matters as well. The explanation of it having to be sick or indigent in order to qualify for the exception is well stated and consistent with prior case law. And the explanation of legal consideration that takes something out from being a donation is also very well done. And I just want to commend Jeremy and the staff for the opinion. I think it's well written, and I thank you. I'm happy to support the opinion.
Thank you, Commissioner Carruthers.
No questions.
Thank you, Commissioner Castillo. Celia.
Okay, oh, great. Well, yeah,
There you are.
it didn't allow me to unmute, but now, yes, I'm unmuted and I have no questions.
Thank you. Commissioner Solomon.
No questions. Thank you.
Thank you. Commissioner Villanueva.
No questions, thank you.
Thank you. Chair has no questions. All right. There's been a motion and a second. No further discussion. Commissioner Baker.
I vote to approve.
Thank you. Commissioner Bluestone.
Yes.
Say that again, would you, just because you cut off in mid-word?
Yes is the word.
Thank you. Yeah, but the recording might not have picked up the whole word. Thank you. Commissioner Carruthers.
Apparently, I just got a message that the host is not allowing us to mute ourselves, so I'm voting yes.
Thank you. I'm sure that the host will look into that right away. Commissioner Castillo
Yes,
and Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes,
Yes, and chair votes yes. Motion carries. Let the opinion issue. Next item, advisory opinion 2208.
Okay, thank you, Chair and Commissioners. For draft advisory opinion 2020-208, the commission was presented with a question under the Campaign Reporting Act from a political committee. The political committee asked, may a political committee make a coordinated expenditure on an advertisement that advocates both the election of clearly identified candidates and the passage of a clearly identified ballot question? So to give you some context, in the upcoming November election, this political committee wants to issue advertisements in the same advertisement where the political committee supports its preferred candidates and also supports a ballot question that will be on the November ballot. And the answer to the question is yes. The political committee can absolutely make that kind of advertisement. The Campaign Reporting Act, apart from requiring disclaimers for certain advertisements, really doesn't regulate the content of advertisements. The Campaign Reporting Act is more geared to regulating disclosure of certain type of advertisements and also to enforcing certain contribution limits. So that's the kind of the place to begin, that this political committee is asking about a regulation with respect to the content of their advertisements, and the Campaign Reporting Act doesn't do that really. The advisory opinion goes on to kind of, again, present the difference, as the commission has done in its previous advisory opinions, between a coordinated expenditure and an independent expenditure. And coordinated expenditures and independent expenditures Both have different definitions. There are different disclosure requirements that are attached to each kind of expenditure, and coordinated expenditures are contributions and subject to a contribution limit, to the contribution limits. The question might have arisen because coordinated expenditures in the definition don't make reference to ballot questions, but the definition of independent expenditure does make reference to a ballot question. And I think that might have created some confusion for the political committee and led to this question. But whether or not an advertisement includes a ballot question, kind of support for a ballot question or not, doesn't really isn't determinative of whether that advertisement is a coordinated expenditure or an independent expenditure. Whether or not it falls in one of those two categories, really it turns on whether or not it meets the definition of a coordinated expenditure, whether or not the PAC worked with a candidate to kind of put the advertisement together. And if the advertisement falls within the definition of a coordinated expenditure, then by definition, it's not an independent expenditure. And the definition of independent expenditure excludes coordinated expenditures. But all of that is kind of just, I suppose, more guidance with respect to how this PAC should determine for itself whether or not this advertisement is a coordinated or independent expenditure, and thus what disclosure regimes apply and what other requirements apply. But to return to the question, can a political committee make a coordinated expenditure that advocates both for candidates and a ballot question? Yes, they can. And with that, Chair, I submit the draft advisory opinion to the Commission for its consideration.
Thank you. Is there a motion and a second?
So moved.
Second.
Thank you. Mr. Baker, anything?
No, thank you.
Mr. Bluestone?
Thank you, Mr. Chairman. I also approve of the opinion and intend to vote yes on it. But I just wonder, for the sake of presentation, as I look at it now, if it would be helpful to amend the answer instead of saying just yes, to say something like yes, comma, provided there is full compliance with the Campaign Reporting Act and its disclosure requirements. Because I think that's what the analysis explains, and that the question was concerned about the relationship between coordinated expenditures and independent expenditures, and the relationship to ballot questions separately. And I don't think it's necessary, but if Jeremy thinks it would be helpful to the public, I would recommend something like that as an additional clause in the answer of yes.
Thank you.
Happy to add that.
Commissioner Carruthers?
Well, I would agree with that amendment, and I think it's rather refreshing that these organizations are beginning to ask these questions prior to the election. And so obviously the State Ethics Commission now has a valuable role in advising these folks before they do get in trouble with the Campaign Reporting Act.
Thank you. Commissioner Castillo?
Yeah, I am fine with the amendment also, and I vote yes, but do you want us to withdraw the original motion?
This is just discussion. No.
Okay.
I'll get to that. Thank you.
All right.
Commissioner Solomon, any comments, questions?
I agree with the suggested amendment as well, Mr. Chairman. Thank you.
Thank you. Commissioner Villanueva?
No questions, thank you.
Thank you. And Chair agrees and has no questions as well. So there was a motion and a second, and there has now been an amendment proposed. Is the mover and the seconder, do you approve of the amendment and adopt?
I approve.
I approve.
Okay. Motion and second amended. Commissioner Baker?
Yes,
Commissioner Bluestone?
Yes.
Commissioner Carruthers?
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
and Commissioner Villanueva.
Yes.
Chair votes yes, motion as amended carries. Thank you. The next item is advisory opinion 2022-09. Walker.
Thank you, Chair. Commissioners, this draft advisory opinion for your consideration is fairly straightforward. The facts are that the requester is an officer of a public post-secondary institution as defined by the Constitution and the relevant statutes. And an officer is defined to include both a member of the governing body of that institution and an employee serving that institution. The question presented is whether the officer or employee can participate in a matter that will result in an increased salary to the public officer or employee's spouse, who is also an employee of the public post-secondary institution. And the answer to that is no. And the reason that the answer is no is that the Governmental Conduct Act prohibits a public officer or employee from participating in a decision or an official act, as the statute uses the term, that will directly benefit the public officer or employee's financial interest. Financial interest, in turn, is defined to include employment or prospective employment, and also to include financial interests, i.e. employment or prospective employment of a public officer's family, which includes the public officer's spouse. So as a result of that kind of pretty straightforward logic, the officer is precluded from participating in a matter that concerns a salary increase for the public officer's spouse. With the caveat, and to reiterate, when the public officer's spouse is also an employee of the same institution. Just to make sure I'm emphasizing that enough. So that's the short answer. Happy to stand for any questions, but I'd be seeking a motion and an approval to issue this advisory opinion.
Thank you. Is there a motion and a second to do that?
So moved.
I'll move.
Thank you. Moved and seconded. Any discussion?
I have a couple of questions.
Sure.
Yes, go ahead. ahead, Judy.
Council, on the question as it reads, may the officer participate in the review and approval of a contract? Are you assuming an employment contract?
Chair and Commissioner Villanueva, the request was not exactly clear on that point, but my understanding was that the contract involves all of the public post-secondary institutions employees. However, the question was phrased in a little more generality than that, so I'm not familiar with what the specific approval is, but my understanding is that it's an approval of a contract that certainly affects the public officer or employee's spouse, but may also affect a larger class of public post-secondary institution employees. The request was not specific on that point.
Okay, well, you actually answered the question that was in my mind, because if you follow along on your analysis, is that Governmental Conduct Act, is that paraphrased, or I can't tell if that was paraphrased or that's the actual verbiage of the statute, where it says it prohibits a public official from taking an official action that directly benefits.
Correct. Directly is in the statute.
Okay, very good. All right, thank you so much.
Thank you. Anyone else?
Yeah, I just have a comment. Can you hear me okay, Mr. Chair?
Yes.
Yes, sir.
Okay. Similar to what Governor Carruthers commented on in the last opinion, I think it's really good that people are coming forward and asking these questions before actions are taken. And I don't know who the individual was who requested this, but I want to commend the individual And I think that it's important that the public know that we're available as a commission to provide this kind of guidance ahead of time and to urge people to come forward whenever there's any question in their minds about whether something complies with the ethics laws or not. And no other comments. I'm happy to approve the opinion. Thank you, Walker, for presenting it.
Excuse
Yes.
me, Mr. Chair.
Yes, ma'am.
Mr. Chair, I have some additional questions. Council, on small point, on subcategories A, B, and C on page 23, I believe that's 23.
Yes.
On C, should that not be no public officer during the term for which elected, or to be consistent with the other language that you've used?
Chair and Commissioner Villanueva, this is a copy paste of the statute. I believe that there's I guess you call it a subordinate clause there that modifies each of the two subjects. So you have a public officer during the term for which elected, i.e. the term for which the public officer has been elected. And I guess there's a little bit of, I think the lack of clarity comes from the fact that the Governmental Conduct Act defines public officer to include both, elected officials and appointed employees. But either way, that provision there has contains, I think, some surplus language saying that a public officer during their term, and then a public employee during the period of their employment.
Right. Okay. Again, the 2 points that I was thinking you just addressed. Okay. If we go to the next page, just before the conclusion, applying this rule, if you start on that paragraph, I'm not sure I believe that could use a little editing. Maybe applying this rule to the facts set out in the request when a public official, comma, perhaps comma, whether employed by or serving on. There seems to be some words missing there.
I see and appreciate that editorial comment, and I would be inclined to accept it. So yeah, I'm happy to include that kind of clarifying language in there.
Okay. One other question on the conclusion. When it said, and I do understand that you're addressing specifically the question. And so your conclusion states when the spouse of an appointed officer, and it specifically states the spouse. Can you educate me on how these advisory opinions are applied? Because this seems to be, is it applied with specificity to the spouse? Because there may be, I see that you have a footnote here that says governmental conduct code defines family, and then you include spouse, parents, etc., and by consanguinity or affinity. But could you also somehow interpret when you're applying the law in a general way to include someone like a domestic partner, or does it specifically have to be spouse?
Chair and Commissioner Villanueva, the Governmental Conduct Act, as you flagged and as reflected in the footnote, defines family specifically. It would be another question whether, it would be a separate question. It's not this request, but it would be a separate question whether a domestic partner or someone who's, I guess, common law marriage or something like that would also be subject to the prohibition. So that's not what's being answered in the request. And as you flagged, yes, that you could include the other, items in the list of terms that are included within the term family. So parents, children, or siblings, right? If in a analogous situation where a public officer or employee is considering whether to approve a contract that will result in an increased salary to their parent or their child, this same conclusion would follow. But as noted, the request is specific. The requester is asking about their spouse, so that's why the conclusion is phrased limited to the spouse. and the request is, it's public. I mean, the advisory opinion is public. It's designed to be educational to the public, but in terms of what the legal effect of the advisory opinion is, it is specific to, the requester, and the requester can now in good faith rely on the opinion in guiding their actions, and therefore be offered some protection from administrative action by the commission. So
For the spouse.
the spouse, well, Chair and Commissioner Villanueva, the spouse is not participating in the approval of the contract. So the spouse isn't, in our view, is not subject to the provision of the Governmental Conduct Act that requires a public official to recuse and not participate in a decision that would result in an increased salary to the spouse. According to the request, the spouse is not involved in that decision. It's the requester, and so there would be no, based on the facts of the request, there is no implied or potential violation as to the spouse, and so that the opinion is not phrased to sort of say, well, the spouse is also precluded from participating. Although if the spouse were involved in the decision, then it would be their own financial interest, and there would be an even stronger argument for the same conclusion, that they're precluded from participating in the matter.
Okay, very good. Thank you.
Thank you. Is there a friendly amendment to the motion to consider the curative grammatical changes that Commissioner Villanueva suggested and that Walker agreed to?
And I've written down.
Everybody good with that motion? Okay, then the motion and second. The motion is to, as amended, is to for issuance of the advisory opinion. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Mr. Carruthers,
Yes.
Mr. Castillo,
Yes.
Mr. Solomon,
Yes.
Mr. Villanueva.
Yes.
And
Yes.
chair votes yes. Thank you very much. All right, and then we move on to item number 7. Walker, this is yours also, the approval of the settlement agreement with Whitlock versus Dow.
Thank you, Chair. Yes. Commissioners, this settlement agreement involves an administrative complaint that was filed with the Commission in fall 2020. It has been the subject of subpoena litigation throughout the year of 2021. At the end of 2021, I determined that the complaint was supported by probable cause, specifically an allegation of an alleged violation of Section 9B of the Governmental Conduct Act. The executive director appointed a hearing officer, Judge Torgerson, to conduct a hearing on the complaint. That hearing was set for July 20th, so about 2 weeks ago. Shortly before the hearing, the attorney for the respondent and I entered into negotiations for a settlement of this matter. Under the settlement agreement, which is at SEC 26 of the public materials, the respondent agrees to pay a $500 civil penalty to the State Ethics Commission for 2 violations of Section 9B within 7 days of the Commission's vote to approve the agreement. The respondent also agrees to dismiss 2 pending appeals of orders entered by the district court relating to the subpoena proceedings in this matter. I'm happy to stand for questions. I recommend approval of this settlement, as you can probably guess, and I would seek a motion and an approval of the settlement agreement. Thank you.
Thank you. Is there a motion, a second, and then we'll move to discussion?
Make
So
that
moved,
motion.
but I would like to comment on the artistic nature of Rebecca Dow's signature.
I'll second it.
Please, the floor is yours, Governor. Let's hear it.
No,
All right.
just a comment.
It's been moved and seconded. Any other discussion? Yeah, Stuart.
Thank you, Mr. Chair. I simply want to point out that the $500 civil penalty for the 2 violations is the maximum civil penalty that the law provides. Because in section 10-16-18, the only penalty available is no more than $250 for each violation. And so we're talking about the 2 violations. And so this is the maximum penalty that the current law would authorize.
Thank you. Anyone else?
Yeah, I've got a question.
Sure, Jeff.
Did Judge Martin sanction Ms. Dow during the course of the litigation?
Chair and Commissioner Baker, yes, Judge Martin entered an order requiring Dow to appear for a deposition and entered a daily $50 fine until she appeared for the deposition. And I don't have the number in front of me, but the respondent was required to pay several $1,000s worth of sanctions pursuant to that order.
And,
$4,400.
Thank you, Jeremy.
and do you know if Ms. Dow paid that sanction?
Chair and Commissioner Baker, yes, there was there was we certainly made we had every effort to ensure that she paid it, and she did pay the sanction as it accrued. So
All right, thank you.
Anyone else? All right, it's been moved and seconded to approve the settlement agreement in Whitlock versus Dow. Commissioner Baker,
Yes,
Commissioner Bluestone,
Yes,
Commissioner Carruthers.
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes,
and the chair votes yes. Thank you, Walker. That'll free up a lot of your time now. All right, it's that time again to, upon motion in a appropriate second, to go into executive session for purposes of discussing administrative adjudicatory proceedings for COVID matter litigation. Is there such a motion in a second?
So moved.
second,
All right, Mr. Baker, you good?
yes, I am. Thank you.
Bluestone,
yes.
Commissioner Carruthers.
Yes.
Commissioner Castillo,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva.
yes.
Chair votes yes. Okay, we will move into executive session. Let's take. We're gonna tell Stuart that his old stomping grounds there. That's really a nice city.
Glad you had a
Aside. Yeah, it was a lovely, interesting place. And it's not, I had pictures in my mind from old photos, and it's not that way anymore. Although I don't know how you learn how to drive there. Everything, there's not a single street that goes straight for more than a block. Everything turns and goes up and down. Oh gosh. But then again, I'm old. So, all right, we ready to go back into session?
Yes, sir. We're here.
Okay. Then Jeremy, item number 12.
Thank you, Chair. So for administrative complaints numbers 2021-38, 2022-07, 2022-06, 2022-11, 2022-14, and 2022-15, the staff would seek a 90-day extension pursuant to the State Ethics Commission Act.
So motion in a second. All right, here's a motion in a second. Any further discussion? Okay, we'll take a vote on it then. Commissioner Baker,
Yes,
Commissioner Bluestone,
yes.
Commissioner Carruthers.
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva, Is Judy not with us?
You're muted, Judy.
She's muted though.
Ah, okay.
Yes.
Thank you. And chair votes yes. Motion carries 90 days. Jeremy?
Thank you, Chair. For administrative complaint number 2022-16, the commission seeks a motion to dismiss the complaint because the Secretary of State's office has certified voluntary compliance.
Okay, is there a motion and a second?
So move.
Thank
Second.
you. Thank you. It's been moved and seconded to grant the order of dismissal in 2022-16. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and chair votes yes. Thank you. Jeremy?
Thank you, Chair. An administrative complaint 2022-17 and 2022-18. The staff seeks a motion for the commission to extend the investigation for another 90 days pursuant to the State Ethics Commission Act.
Is there a motion and a second?
So moved.
Second.
Thank you. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes. Motion carries 90 days extension granted.
Thank you, Chair. In administrative complaint number 2022-21, the staff seeks a motion that the commission dismiss the complaint because the Secretary of State's office has certified voluntary compliance as to the CRA claim, and the commission lacks jurisdiction as to the Governmental Conduct Act claim.
Is there a motion and a second?
So moved.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Mr. Carruthers,
Yes.
Mr. Castillo,
Yes.
Commissioner Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes. Motion carries. Thank you.
Thank you, Chair. For administrative complaint numbers 2022-23, 2022-24, 2022-25, 2022-26, and 2022-28, the staff seeks a motion to dismiss these complaints because the commission lacks jurisdiction.
Thank you. Is there a motion and a second?
So
So
moved.
moved.
Thank you.
Second.
Moved and seconded. Any discussion? Hearing none.
Yeah, Mr. Chairman, I'm going to recuse from 2022-23. My law firm represented the town of Taos in an employment matter. We worked very closely with Mr. Bellis during that lawsuit. And I don't think it would be appropriate for me to participate in that particular item.
Thank you. All right, with that noted, on K through P, then there's a motion and a second. No further discussion. Commissioner Baker, with the exception of that one case, you're in favor of the motion?
Yes, I am.
All right, Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes. Thank you. The motion carries. All right, next is the administrative matters under the revised uniform law on notarial.
Chair, but before that, I believe Walker might need to present motions for open session for the settlement approvals that were decided in closed session.
Okay,
Thank you.
thank
Thank
you. Well, go ahead.
Chair and Commissioners, the Commission staff seeks a motion approving the settlement agreement in the matter captioned Randy Bates versus Raymond Drake, number 2021-26. I'll refrain from explaining the settlement agreement in this matter, as the settlement agreement will be made public on the commission's document, and as will the complaint.
Okay. Is there a motion, a second?
So move.
Second,
Thank you. Any discussion? Commissioner Baker,
yes,
Mr. Bluestone,
Yes.
Commissioner Carruthers,
yes,
Mr. Castillo,
yes,
Mr. Solomon,
Yes.
Mr. Villanueva.
Yes,
Chair votes yes. Thank you. Next.
Chair and Commissioners, I am seeking approval of a settlement agreement in the matter captioned Stephen Garrett versus Mark Ronchetti for governor, number 2022-08. The commission has instructed me to provide some further explanation of this. So I'm going to describe the complaint shortly and then explain a little bit of the basis of the settlement agreement. The complaint alleges that the campaign committee for Mark Ronchetti aired 2 television advertisements that lacked required disclaimers under state law, the Campaign Reporting Act. 1, I'm running for governor, and 2, Mark Ronchetti for border security. I've investigated those complaints. The first advertisement, I'm running for governor, was not aired on television and therefore is not subject to the Campaign Reporting Act's candidate disclaimer obligations. However, the second one, Mark Ronchetti on border security, was televised and therefore under regulations promulgated by the Secretary of State was required to contain an image of the candidate stating his approval of the advertisement, which the advertisement initially lacked. However, the candidate took steps to correct the issue as soon as it was alerted to the campaign. The advertisement was corrected to contain the required disclaimer statement, and that statement was contained in all further televised transmissions of that advertisement. Further, as the candidate has pointed out, the Secretary of State's informal guidance to candidates for the 2022 primary election cycle does not have any mention of the candidate disclaimer obligation, and I concluded that the candidate had relied on the absence of that instruction in there as the reason for not including the disclaimer in the advertisement. For those reasons, I thought that a settlement was reasonable, and the settlement agreement I reached with the candidate committee was a suspended $500 civil penalty, and it is suspended on condition that Mark Ronchetti for governor agrees to comply with the disclaimer obligations for televised candidate advertisements set out in 1.10.13.31G New Mexico Administrative Code until the end of this year. With that, I would seek a motion approving the settlement agreement. Thank you.
Thank you. Is there a motion, a second?
so moved,
Second.
Thank you. Been moved and seconded. Any other discussion? If not, Commissioner Baker,
yes,
Mr. Bluestone,
Yes.
Mr. Carruthers,
yes,
Mr. Castillo,
yes,
Mr. Solomon,
Yes.
Mr. Villanueva,
yes,
and the chair votes yes. Thank you. Motion carries. Settlement is approved.
Chair,
Thank you.
before we turn to the Rolona matter, Sue has informed me that I was remiss and I missed administrative complaint number 2022-022, for which the staff seeks the commission's dismissal for lack of jurisdiction.
Thanks. Is there a motion, a second?
so moved,
second,
Any discussion? Commissioner Baker,
yes,
Mr. Bluestone,
Yes.
Mr. Carruthers,
yes,
Mr. Castillo,
yes,
Mr. Solomon,
Yes.
Mr. Villanueva.
yes,
Chair votes yes. Thank you. All right, now on to the Rolona matters. Becky?
Yes, Chair, Commissioners, in re Notary Public Commission of Hyatt 2022 NP01, staff requests issuance of a default order and referral to the DA's office for criminal fraud.
Okay, is there a motion, a second?
So moved.
Second.
Thank you. Any further discussion? Mr. Baker,
Yes.
Mr. Bluestone,
Yes.
Mr. Carruthers,
Yes.
Mr. Castillo,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Thank you. Next one.
In Re Notary Public Commission of Radigan, 2022 NP 11, staff seeks request issuance of a default motion or default order, sorry.
All right. Is there a motion, a second?
So moved.
Thanks. There's a motion and a second in there, and no further discussion. Commissioner Baker, your vote.
Yes.
Mr. Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Mr. Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Thank you. And the last one.
In Re Notary Public Commission of Fulfur, 2022 NP 14. Staff request approval of settlement agreement, which would require Mr. Fulfur to be on probation for 6 months and take and complete the notary public class and pass the subsequent exam with at least an 80%.
All right. Is there a motion and a second?
So moved.
Second.
And any further discussion? Hearing none. Commissioner Baker,
Yes.
Mr. Bluestone,
Yes.
Mr. Carruthers,
Yes.
Mr. Castillo,
Yes.
Mr. Solomon,
Yes.
Mr. Villanueva,
Yes.
and chair votes yes. Thank you. Thanks, Becky. Next item is discussion of the next meeting. Hopefully you got the notice a couple weeks ago that due to a long overdue and richly deserved break, I'm going to be on travel for a while. So on October 14th, we will conduct our next meeting, and it will be in Santa Fe, in person. Hopefully I am over whatever this this thing is that I have that was COVID, that wasn't, then finally is. So October 14th in Santa Fe, it'll be a full agenda and discussions with other commissioners and with the executive director. It seemed like a good idea to make an appearance at the state capitol, since we haven't done it in a long time. And it seemed like a good idea to do right before the session. So October 14th in Santa Fe, more details to follow. And it'll be in the Capitol building. We have a room reserved. That leaves us to public comment. Walker.
Yeah, folks who are here to make public comment, would you please use the raise hand feature to indicate your desire to make a public comment? I think everyone here there might be someone here on phone. If you're on a phone, I think you press *9 to raise your hand.
Getting any takers?
No bites. I think maybe the audience is also feeling fatigued. The raise hand button is under the reactions tab if you're looking for it.
All right.
I'm not seeing anything.
Going once, going twice, and thrice. All right. That leaves us with only one thing left to do, and that is to proclaim adjournment. Okay. Thanks, everybody.
Thank you, commissioners.
Thank you.
Bye.